Number 107, the people of the state of New York versus Tyrell Cook. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Alexandra Mitter, and I represent Appellant Tyrell Cook. Before I begin, I'd like to reserve 2 minutes for rebuttal, please.
Yes, you may. Ms. Mitter, is it your position that a hearing court can never reopen a suppression hearing after the prosecution is rested?
That is not my position at all, Your Honor. My position is that the people get one full and fair opportunity to make their best case against suppression. The Court nevertheless retains ample discretion to decide that something has denied the people this full and fair opportunity.
So is that essentially the Havelka rule you're asking us to apply?
Absolutely, and Kevin W. There's a long string of precedent here that says the people get one full and fair opportunity.
Kevin W. already said that.
It absolutely did, and it said that Havelka applies in the pretrial setting. It didn't say it applies in this very specific pretrial posture that we happen to find ourselves in.
Kevin W. talks about a balance, right? And you're balancing certain policy issues, and you're balancing finality and the fact that a party should be prepared for the hearing. And we're striking that balance. And Havelka talks about, factual circumstances and applying a rule in a logical way. And so in Havelka, we did that after appellate review, and the case was sent back. And we said no. We applied the Havelka rule, which had developed over time in other cases.
Sure.
And then we got to Kevin W., and we rolled that back to post-suppression decision. And that case is clearly about a decision to reopen a hearing after the court had ruled. So now we're faced with a different factual circumstance, and we're again looking to balance those interests. And if you're looking at finality and preparedness, and you're looking at the other policy reasons and the problems that were identified in Havelka and the other cases about tailoring and about the haunting specter of non-finality, why is it that we should strike that same balance when there's been no formal ruling by the suppression court?
Because I think during oral argument, and particularly during this oral argument here, all of the same things that caused this court and Kevin W. to say we are concerned about finality, we're concerned about tailoring, we're concerned about all of those things that you just mentioned, all of those things happened in the oral argument here. The court identified, quote unquote, the issue, and then explained to the prosecutor that if a counterfactual that had not been presented
assume that may even be true here, and I'm sure your colleague on the other side will disagree, but assume that's true here. Aren't we making a rule for all time? So your rule is not you look at that and see how much did the trial judge signal. Your rule is never, ever, ever, only if they didn't have a fair opportunity.
Well, I think you have to start from the premise. The first principle here is that everybody, the people in this particular situation, get one full and fair opportunity to meet whatever it is their burden is. In this particular situation, opposing suppression. You get one full and fair opportunity, and there's ample reason for that to be the starting position. The point is, you have to show that something denied you that full and fair opportunity. Otherwise, what is the point of the rule in the first place?
That's assuming we adopt your rule. And the question for us is, do we adopt that rule, right? I mean, do we apply full and fair opportunity, which is a very limiting principle, to restrict any discretion other than for those limited reasons by the trial judge an hour after the suppression hearing closes?
I think that here, the point is that in Kevin W., this court articulated a rather broad principle that Havelka applies with equal force in the pretrial setting. Though that's the language of this court's decision.
And they talked about implicit or explicit direction from the court about basically what was missing, right?
They did indeed, and that's precisely what happened here.
So I think the question is there a reason to apply a different rule in a suppression hearing where there hasn't been a formal ruling than there is in the other contexts in which we've applied that rule?
I think there's absolutely no reason to draw the distinction that the people are proposing to draw here. All of the concerns that were at issue because a formal decision had been rendered in Kevin W. are happening here because the prosecutor was getting precisely the type of both implicit and explicit direction from the court about the problem with his case, and he understood what was happening.
Is that a limitation on discretion? I mean, how does discretion fit into that?
So
to this
discretion fits in a number of ways. I mean, the court could realize that it hadn't actually done that implicit or explicit direction. I mean, I think there's a number of ways in which the court could say, you've rested, we've started argument, but for the first time now the defense attorney is raising an issue that had never been raised before, and so you should be allowed to address that legal issue by reopening the suppression hearing.
So let me ask, if the court,
Yes.
listening to oral argument, doesn't say a word, not a word, but the prosecutor hears something the defense counsel has said, and at that point requests to reopen to present additional evidence.
I mean, I think that presents a closer question, Your Honor, and I think
Okay,
that's
but what's the answer to the closer question?
Well, I think it depends on precisely how it came out, because we're not trying to have defense counsel act as sort of a second seat to the prosecutor here to identify all the issues that the prosecutor, because it is his burden, was supposed to have realized in the first instance. Now, I'm not trying to say...
The thing that worries me, I think, though, which relates to your last answer, is that you're asking us to substitute a pretty bright line rule, right? When is there a formal ruling? With something that's pretty mushy, that will require appellate courts to decide, has there been implicit signaling? How do we interpret these words? What did the prosecutor make of that? Or, take Judge Rivera's example, which is even a little bit to one side of that. What if the court said nothing? Or what if the court is nodding and we can't see that on the record? That's a hard problem.
No, I understand the difficulties that this creates, but as all of your honors have expressed concern so far, we want to give the trial court discretion in that instance to decide what makes the most sense.
So what would the rule be?
I think
if you were successful, what
Sure.
would you ask?
I mean, I think in the first instance, I would argue that the rule should be that once the parties have rested, the full and fair opportunity has ended. I think as a fallback position, once the court and the parties have started engaging in oral argument, and precisely that type of explicit or implicit indication of the deficiencies in the case have come to the fore, that is the moment at which the
So
full
you
and
would
fair
say,
opportunity
your
has
first
ended.
position, though, is the court wouldn't have any discretion to reopen?
No, not at all, Your Honor, because I
Okay.
think there's a number of things that prevent that the court could find or not find prevented the people from having that full and fair opportunity. For example, as I mentioned earlier, all of a sudden they start arguing about something that hadn't really been at issue in the omnibus motion, and as a result wasn't at issue in the suppression hearing. So at that point, the prosecutor, of course, should be allowed in the court's discretion to put on
So
evidence
when
to
they
address that.
can't, from your rule, is if the judge determines that the prosecutor's evidence is deficient, but the prosecutor had every chance to present whatever evidence the prosecutor wished to present.
I think
That's where you say they don't get that opportunity, regardless of what the judge may say, whether the judge nods, regardless of...
I want to make sure I understand your
comment?
honor's question correctly.
Well,
So-
I'm trying to find out where you draw the line, since you're saying you don't have a bright line rule, although I think you do.
I draw the line at the point that all of the concerns in Havelka and Kevin W. are implicated, which here, and in many cases, happens during oral argument, when the deficiencies are being identified in the case.
That's what I'm saying. So when you say, no, the judge does have discretion, and you return to this focus on whether or not the prosecutor had full and fair opportunity, right?
Absolutely.
To present whatever evidence the prosecutor wanted to present on the
Absolutely.
respective issue, which I take then to be the flip side. If the judge decides that and you can correct me if I'm misunderstanding you, if the judge determines that what has happened is not that the prosecutor couldn't come forward with evidence, that they just didn't have the opportunity to do so, but they've come forward with whatever evidence they were intending to come forward with, and it falls short.
I agree. At that point, under Kevin W., the court no longer has discretion to reopen. That's the line.
Has any appellate division court applied your rule?
I think there's plenty of appellate division courts that say that a court properly exercised its discretion to deny reopening.
Right. But they're
because-
assuming discretion.
And I continue to assume that
And there
discretion.
are courts that have said they properly exercised their discretion to reopen in cases that did not fit within the Havelka except.
In the First Department, absolutely, and I think the First Department is doing that based on a
No other
misunderstanding of
department
this.
besides First?
Not in the way that the First Department is doing it. I think there's other departments decisions that are being cited by both sides here. But to the extent that they're giving a reason for why that discretion was properly being exercised to reopen, it fits within exactly what I'm talking about here. You know, Hernandez, where there was a new issue raised in oral argument, Whitmore, where there was a new basis based on the defendant's testimony that the prosecutor had no reason to.
If you have the Havelka factors, you can reopen. I mean, the question is, if you don't, can you?
I don't know, Your Honor, but we are within Havelka and we are within Kevin W. and all the concerns raised therein.
Thank you, counsel. Counsel?
May it please the court, Chair Knight for the people of Bronx County. This court in Kevin W. stated that the truth-seeking function of a suppression hearing is critical.
But that's true about trials, too, right? And we certainly have applied similar rules in the trial context. Why is suppression different?
Because it's getting to the truth of whether or not there was unlawful conduct by the police.
Yes, and so what is the significance of that as opposed to getting to the truth of whether an accused person did or didn't commit a crime?
Because we're evaluating whether or not a defendant's rights have been violated. So
do you think that there are any limitations on the court's exercise of discretion under these circumstances, or whenever the people figure out that they want to introduce more evidence, they ask for it, and in a sense, then it's never an abuse of discretion to agree to reopen?
no, I'm not saying that at all.
So what are the limitations you think are on the court's exercise of its discretion?
I would say Kevin W. and Havelka, that it's when the court has rendered a decision, and before that, it is within the court's discretion.
Unlimited discretion.
No,
But
you
that's
need
my
to look at
question.
certain things.
That's my question, is we know Kevin W. and Havelka and the context in which that rule was made. Now, we have a slightly different context, and my question is, in this context, what, if any, limitations are there when there hasn't been a formal decision on the merits?
Well, we need to consider the concerns that were brought forth in Havelka, such as the tailoring of testimony.
So what would be an example of where a judge could not, exercise their discretion to permit reopening without it being an abuse of discretion? What would be an example from the people's perspective? This is an attempt to see how you might be able to respond to what I think Judge Stein is getting to.
If there were shown to be bad faith on the part of,
Bad faith by who?
by the people, which in this case, there absolutely was not.
And what
There
would
was
that
good
look like? What do you
faith.
mean by bad faith? Let me ask you this one. Let's say the court, they've rested, and now they're in oral argument, and the court peppers the prosecutor with a lot of questions. Perhaps does the same to defense counsel. Then perhaps presents some rhetorical questions like, doesn't it look like your evidence could, your argument would be more persuasive, it would be stronger if you had called officer so-and-so, or if someone had testified to this, or if you presented the following document. Wouldn't that perhaps make your case look a little bit stronger? Maybe that would take it over the line. And the prosecutor says, you're right, Your Honor, I'm moving to reopen so that I can submit all of that information.
Right, but
Does that get close to tailoring?
no, I mean, the judge is,
Hasn't the judge said what I think is wrong with your case, go put it on?
well, it's an ongoing colloquy between the judge and the parties to flesh out issues, and that's what happened here, is during the discourse.
Well, to flesh out issues based on the record as it stands, as opposed to your evidence falls short. Go beef it up.
What if during argument the judge says, okay, here's what I think I'm going to do, but I want to sleep on it for a couple days? Is it then too late to reopen?
No, he hasn't rendered a decision at that point.
Even if he's sort of read a tentative decision into the record and said, but I'm not sure about this?
I mean, I think it's a closer call.
Okay, well,
But
that's
here
what
they're
I'm trying to
definitely,
do.
Yeah, there definitely was not a decision rendered in this case.
So
Doesn't
in
seem
this
there's a lot of
partic-
room
And-
in your approach for the judge ever to be viewed as having abused their discretion by permitting the reopening of the suppression hearing for the prosecution to present additional evidence to address gaps or deficiencies
Well,
in
if
their
there's good faith
presentation.
on the part of the prosecutor, and if issues come forth, there are preservation rules. There's no reason why the people should not be afforded the opportunity.
So what do you
to
mean by
cure a
good faith? The
deficiency.
prosecutor thought it was a good case, and now they've realized, perhaps I'm missing something?
He may have misjudged the strength of his evidence, and that shouldn't prevent him. This isn't a gotcha principle of law, as was, disapproved of by this court in Whipple. That's not the point. It's to get to the truth. So in order to get to the truth, if the people need to bring forth more evidence, or if the court,
But if
So
the only
let me
principle
try
were,
to, I'm sorry.
I was just going to say, if the only principle were getting to the truth, we wouldn't have Havelka.
right, but the concerns in Havelka are considered by the court
Let's
in
bring it
their
back to-
evaluation of whether or not to reopen the hearing. If they feel there's going to be a great risk of tailored testimony, that would be an example where they may not reopen a hearing. Or if
Well,
there's a case where, if the witness that the people would want to put on the stand has evidence that is completely irrelevant to the issue that they're dealing with, that would be another example where a judge would deny reopening a hearing. And there was a case like that where the people wanted to bring in 911 evidence, and the court denied the reopening of the hearing because the 911s were not relevant. So if it's something that's not relevant to the issue at hand, or if there's a high risk of tailored testimony, then that would be a point where the judge, in his discretion,
So
would
that-
deny the people an
so-
opportunity to reopen.
A lot of this does talk about the risk of tailored testimony. So I guess if we narrow it down to just that, so what circumstances are there that show that there's a high risk of tailored testimony? Wouldn't a court indicating that it didn't think that the evidence was sufficient, or that perhaps some other evidence would add, as Judge Rivera alluded to, wouldn't that create a high risk of tailoring, even if there hadn't been a formal decision?
Well, there are protections in place to prevent or detect tailored testimony, and one is the judge,
Well,
who's,
but if that's true, then then you're not talking about the risk of tailoring, then you're talking about looking back and to see if in fact there was tailoring. Those are two different things, aren't they?
yes.
Okay, and the second thing you can only determine after you've already given permission to reopen the hearing.
True,
Okay, so which is?
but I think there might be certain circumstances where a judge might feel there is more risk, if it's something where it comes down to one thing that needs to be said, or it depends on the circumstances. But the cases in the First Department, as my adversary claims the First Department is apart from the other departments in their understanding, they all talk about, and they all consider tailoring. And actually, one of the cases that was handed to the court, in this case, Sestelano actually cited to a second department case, Sudville. So there's absolutely no misunderstanding of how Kevin W. and Havelka apply in the pretrial setting, and how they also interact with Whipple, because it's not incompatible.
So let's actually then apply to the facts of this case as opposed to a hypothetical. What actually, in your view, transpired? did the judge actually signal somehow his understanding? How do you think the rule plays out when applied here?
I think there was an ongoing spirited colloquy that was going on between the court and defense counsel where issues were being fleshed out. And this was the people were in the midst of a full and fair opportunity throughout these two hearings. And as the
Did he
issue,
ever suggest that the whole issue of the sweating was the decisive issue in his mind?
did the judge?
Did the judge, as opposed to
It was a
either of the
concern. It was an issue that the judge definitely wanted more information on. He had requested the transcripts. I just want to point out that this judge, as far as implicit and explicit direction, he didn't believe that he had the discretion to reopen the hearing. So that absolutely did not occur in this case. He was not telling the people, here's what you need, ask me to reopen, because he didn't believe he could reopen.
Right, and then he comes back the next day after the people bring certain
Do research.
cases, and he reconsiders that ruling.
And right.
And sort of it's what you're describing as the judge believing the interpretation of Havelka and Kevin W. is, I cannot reopen this, I don't have discretion, is that he felt at great liberty to explain what his concerns were, which does create the risk of tailoring.
Yes, but the judge also is well-equipped to determine whether there has been tailoring, and the judge here also assured defense counsel that she'd have ample opportunity to cross-examine the witness. So there are protections in place to prevent tailored testimony.
Well, cross-examination won't prevent the testimony. I think your argument is that we would hope that cross-examination might show some weakness that suggests that it's tailored testimony, but it will not prevent it.
But the decision would not be upheld if it was shown that there was tailored testimony.
One would hope.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honors. I'd like to just briefly respond to where my adversary ended and then get to the 330-30 issue, if I may, because I think that where respondent just left off sort of gave the game up. She said, we were in the midst of our full and fair opportunity while oral argument was happening. And that's just simply not the case under Kevin W. And so I think, to be clear, what the court said, because we want the court to be able to explain exactly what it thinks the problems are so that there can be a give and take in oral argument. If people are worried about what they say in oral argument leading to reopening sort of ad hoc, then we're going to be chilling exactly that argument.
Doesn't
And
your rule lead to the court being careful not to ask questions?
No, I think the rule suggests that the rule is designed to encourage the people to have done the research, understood their case, and come with what they believe is their best case. And sometimes that won't be enough, and that's okay. That's how it works. So I'd like to get to the 330-30 issue just briefly, if I may. Because what we have here is two jurors, one of whom was a holdout in favor of acquittal, telling everyone that an MTA employee who was on the juror told them that there would have been video at the subway stop in question.
Wasn't that common knowledge? And didn't defense counsel, in fact, raise that in his examination of
It's not common knowledge, Your Honor, and I think there's a couple
Counsel,
problems with that.
My 8-year-old points out the video cameras on the subway platforms to me.
What the court said here was that post 9/11, everybody knows that there's surveillance. And while we might know that we're in a surveillance state kind of writ large, what we don't know is that every subway station, including the one at issue, has cameras, that those cameras record, and that those recordings and the Metro card swipes, by the way, there's two pieces here, that those would be available to defense counsel. Effectively what happened.
Once counsel is trying to point out the weakness of the people's case, that the investigators could have gotten the surveillance video, or at least didn't try to get it, didn't try and find out anything about the Metro cards, that it would be the natural thought of a juror, perhaps incorrectly, depending on the instructions from the judge, to wonder, gee, why didn't the defendant bring that forward if it's exculpatory.
So if the jurors had that question and they wanted to, they sent out a note saying, Your Honor, can we consider that the defendant didn't do that? The answer would be no. You can't consider that, and there would be a re-instruction that the burden remains with the people on this point.
Yes, but I thought your point was that the problem is that there's one juror who's sort of stoking the fires about this issue based on some expertise or information that juror brought into the room.
Absolutely. I mean, effectively what we have here is that the MTA juror sort of built the record and made the case for an adverse inference that was then held against Mr. Cook for documents not in his possession. But because this happened in the jury room instead of in the courtroom, defense counsel had no ability to, for example, point out the practical difficulties of obtaining that evidence. And so I think for all of those reasons and the reasons in our brief, this court should reverse the
counsel,
conviction.
if I just ask, did counsel ask for some kind of instruction to the jury
At what point, Your Honor?
regarding this issue?
Regarding this issue, they didn't know about this issue until after the fact of.
No, not about the juror. I'm making this argument, please, maybe you want some other kind of instruction related to what is the burden that the that the people carry, that the defendant bears no burden.
There was discussion of the fact that the burden doesn't shift because the people had engaged in some burden.
The usual instruction on that. I'm asking, was there any request perhaps for something
Defense counsel did, in fact,
given this questioning?
Defense counsel did in fact ask for more and was denied that.
Thank you.
Thank you.
Thank you, counsel.